Our speaker today was born in Alberta and is a BYU graduate. Let me give you a little bit of his background. Born and raised in Alberta, has an intimate knowledge about the workings of the Canadian federal and provincial legal systems, particularly as he's been doing research on this over the past few weeks. He matriculated here at Brigham Young University, and then went on to receive his law degree at Stanford University, and then began to practice law in Arizona beginning in 1963, and then was named to the Supreme Court of Arizona, and has recently retired as the Chief Justice of the Supreme Court of Arizona. So we have a person whose development stage was in Canada, in Western Canada, and then has spent most of his adult life in the Western United States. And so he's eminently qualified to speak to us about the judicial process, institutions, and influences that stabilize two nations. It's a great pleasure to introduce to you the Honorable Charles E. Jones.
Thank you, Professor Fry. I am convinced at this point that my knowledge, such as it is, of the Canadian judiciary and the judicial systems of Canada is not quite as extensive as you might describe. But before beginning, I want to say that I'm honored to be here. This is my alma mater. This campus has changed a great deal. About 1 in 3 people are now talking on cell phones. We didn't know what cell phones were in those days. And I want to thank the university and also the Palmer family, whom I have known throughout the years of my life. It's a pleasure to be here in recognition of the enormous contributions of Asil and Maydell Palmer in southern Alberta. I knew them well during my early life. President Palmer, as we knew him, presided over the Lethbridge stake for 21 years, from 1926 until 1947. But his contributions did not end there. He went forward, and he was an expert in the fields of irrigation and agriculture, having served as the superintendent, if that is the correct title, superintendent of the Dominion of Canada Agricultural Experimental Station, located just east of the city of Lethbridge. A wonderful family, some of whom are here today, and the contributions they have made in southern Alberta and elsewhere are not able to not describable in just a few moments. I acknowledge members of my family who are here. My wife Ann is seated here. If you raise your hand, Ann. My daughter Ruth Todd is seated near the back. Came in just a minute ago. My sister-in-law Sue Marie Young is seated here in the front, and my sister-in-law Nancy Anderson is also here. And Jen Todd, where's Jen? Jen's back there with her mother. Jen is a freshman student here at BYU this year. I've been asked to discuss similarities and differences between the judiciaries of Canada and the United States. That is a huge subject. And I knew when asked that my knowledge of Canadian judicial process was sparse. I do, however, understand a number of things. Both nations' laws and procedures are rooted in the common law of England, and both systems follow what lawyers and jurists on both sides of the 49th parallel refer to as the adversary system, a courtroom procedure developed in early England to resolve disputes brought before the courts. I am also aware that the civil law systems of Europe, parts of Asia, Central and South America, including to some extent the province of Quebec, and also the American state of Louisiana, differ substantially from the common law systems in use in most of the English-speaking world. Traditional common law jurisdictions, including Canada and the United States, reflect the English system of interrelated bodies of court-made law, as modified by statutes and built on the concept of legal precedent under the common law doctrine of stare decisis, a Latin phrase meaning that when a court has once laid down a legal principle as applicable to a certain state of facts, it will adhere to that principle and apply it to all future cases where the facts are substantially similar, regardless of whether the parties or the property involved are the same. Let me depart from written text and give you a description of the structure of the courts, both in the United States and Canada. In the United States, we operate within two separate and rather independent judicial systems. Those of you who are in law school, if any, will learn this in the first week of school probably, and some who are not may find it interesting. But in the United States, the federal court system and the state court systems exist side by side, but rarely do their paths cross except from time to time at the Supreme Court of the United States level. Courts of the United States consist of, at the general trial jurisdiction level, courts that are located in 94 federal districts across the country in all 50 states. Utah, for example, is part of the 10th Circuit Court of Appeal, headquartered in Denver. Arizona, Montana, Idaho, and the western states are a part of the 9th Circuit Court of Appeal, located in San Francisco. The Supreme Court sits at the apex of the federal system, and these are courts, as we refer to them, of limited power and jurisdiction. And I'll come to that a little bit later in my comments, but they are courts that are authorized to exercise jurisdiction only when federal questions arise and when federal issues are brought before them under the Constitution of the United States or the laws enacted by the Congress of the United States. And that is the extent of their jurisdiction, one exception being diversity jurisdiction, where you have citizens of two different states battling it out. And even there, the federal courts are bound to apply state law. In the United States, we have the separate state court system. In fact, we have 50 of them. Each state has its own system of courts, each with its own grant of judicial authority under the state constitution, each with authority to administer the laws of that state free and unfettered from federal interference. Again, this is a reflection of things that took place as early as 1787, when the founders and drafters of the United States Constitution put this nation together in the first instance. So it is fair to say that federal courts in the United States cannot interfere with the administration of justice at the state level unless a case presents a substantial federal question. And by the same token, state courts cannot dictate federal law to the federal courts of the United States. Now, that may seem complex, but it has worked rather well during the course of our 200 years plus history. One other comment: state courts exercise general jurisdiction. That is to say, they have jurisdiction without reservation over all matters of law arising within the jurisdiction of the state. They are in that regard different from the federal courts, which, as I mentioned, are courts of limited jurisdiction, restricted by the very language of the United States Constitution, which says in effect that their judicial power is limited to exercising jurisdiction over federal questions arising under the Constitution and the laws enacted by the Congress. Canada took a different course in the establishment of its courts. As I read and attempted to gain a better understanding, I concluded that a fair characterization of the courts of Canada would be that they form a single, national, integrated system with jurisdiction over all questions of law, whether federal or provincial. The British North America Act was adopted by the British Parliament in 1867, and under that act, the responsibilities undertaken by the Canadian courts would be divided between the provinces and the federal government, or the central government. And bear in mind that in both situations, the United States and Canada, what we're dealing with here is the distribution of judicial power and how it should be exercised. Canada chose to establish a single system with responsibility assigned to the courts located in the provinces to manage the courts, to administer the courts, but not to pick the judges. Judges in Canada are selected in Ottawa. All judges in all of these courts that have federal or provincial jurisdiction. and Ottawa pays those judges. All compensation of the judges that sit in these courts in Canada and throughout the 10 provinces are compensated from Ottawa. When the British North America Act was enacted by the British Parliament and came to Canada, there were many questions that had to be answered. And one of them stemmed from the American Civil War. If you keep the time frames in mind, the American Civil War went from 1861 until 1865. The British North America Act was enacted in 1867, just 2 years later. And the founding fathers in Canada, including Sir John A. Macdonald and Wilfrid Laurier and others, concluded that there were some exposed weaknesses in the American system by having limited the powers of the federal government the way the Constitution had done. They did not want that situation, and so in distributing the powers under the BNA Act to the courts of Canada, it was determined then and there that Parliament would reign supreme, and that the model of the parliamentary model of British government would be that the Canadian Confederation would adopt. The courts in the provinces consist of 2 levels. Number 1, the general trial jurisdiction level. These are the courts that are extant in all of the urban areas of Canada, throughout all the provinces. They're available to all citizens. And then a court of appeals at an upper level, which is also located in each province, keeping in mind that these courts are federal as well as provincial. These courts essentially have formed, as one historian described, the linchpin of Canadian jurisprudence. Why is that? It is because in addition to the powers that come to them through the parliamentary source, they also have what we call inherent judicial power. Thus, in Canada, if Parliament enacts a statute or law that would call into play responsibilities of the courts of Canada, it is presumed that under the Act says nothing about who should determine or where disputes should be resolved. It is presumed in Canada that these courts have the inherent judicial power to sit in those cases, and they do. And that is exactly what happens. Of course, at the apex of the Canadian judicial structure is the Supreme Court of Canada. Parliament in the intervening years has also created a federal court of appeal that handles certain types of cases, limited cases, and also a court of tax appeals that handles nothing but tax cases coming up. But by and large, the judicial system of Canada filters through these courts in the provinces onto the Supreme Court of Canada, not unlike the systems in the United States, with the exception that jurisdiction in Canada is general, it is as broad as it is long, and there are no limitations, contrary to the situation in the federal court system in the United States. Both the Supreme Court of Canada and the Supreme Court of the United States are courts of discretion. That is, they hear appeals when they decide to hear them. No one goes to the Supreme Court of the United States unless a petition for certiorari is granted. And by the same token, no one goes to the Supreme Court of Canada unless leave to appeal is granted. Let me just give you a little more on the history of this entire matter. In 1787, the constitutional debates took place in Philadelphia. They were at sometimes heated and very arduous. Some of the delegates who came from all 13 colonies along the Atlantic seaboard from Maine to Georgia were skeptical. They were uncertain as to whether anything positive could come from this convention. But they got into the debates over how to distribute the powers of government. One of the key issues that was debated in the American Constitutional Convention in 1787 was the question of separation of powers. The Americans at the time were very distrustful of the British Crown. They had just fought a bitter war, and much bloodshed had resulted. Some in the convention urged that the judicial branch of government should be appended to the legislature and subordinate to the legislature, such that the Congress of the United States would basically control the courts of the United States. And there was a fairly strong argument to that effect. The argument, however, was rejected. Hamilton, a Federalist, and others said, no, we need more strength at the federal level, and we must diffuse the power such that there not be a concentration of excess power in the hands of any one person or any single institution. And so that argument prevailed in the convention. The United States Constitution was therefore established with three distinct, co-equal, and separate branches of government. Alexander Hamilton, in the Federalist Papers written later on as he urged the states to ratify the Constitution, referred to the legislature as having the power of the purse. That is, how do we spend national money, the national revenues? The executive branch would have the power of the sword, said Hamilton, the power to execute and enforce the laws. And the judicial department, said Hamilton, would have the power of judgment or will. He characterized the courts as the weakest of the three. Many today would disagree with that because of the very powerful role that the courts have been called upon to play in a variety of issues that we have seen even in our time in recent years. The separation of powers doctrine had far-reaching effects in this country. In the United States, we succeeded in separating the powers of government on an express basis. That is to say, it was written, it was clear, and it was determined that the Supreme Court of the United States, would exercise constitutional judicial power. That is, power given them not by the Congress, not by the executive, but by the people through the express language of the Constitution. In Canada, similar, as best I can assess Canada, it seems to me that a similar balance between freedom on the one hand and order on the other was achieved through the parliamentary process, which we do not have in the United States, with a rather strong opposition party that always served as a restraining influence on the actions of government, both in England and in Canada. We observe here the actions of the minority party in the Congress, as well as the majority party, and sometimes they are literally at each other's throats in deciding what policy should be. But in either event, it seems to me that a proper balance was achieved between freedom and order, such that the people could enjoy basic freedoms, whether in Canada or in the United States or in England for that matter, unfettered from the encroachments of improper governmental procedures. Can't read my watch here. Yeah, I don't want to go too long. A little experience, which ties into this, I think. I was reading a couple of years ago an article that had been published in the Toronto Globe and Mail newspaper in Canada by a Canadian columnist. This article may have been reprinted in one of the eastern newspapers in the United States. I can't remember. But his point was that if Americans had simply been patient in 1776 and waited and worked with the British, they could have achieved peaceful independence as Canada had done in 1867, 80 years later, if they had the patience. And I thought, well, he may have a point, but I thought further, and I decided that if you were to ask Canadians to list the 10 most redeeming characteristics of the American people, patience would not be one of them. And so we went ahead and went to war, ill-prepared, ill-equipped, under Washington's command, and were able to successfully force a complete and total withdrawal of all British influence. The Canadian independence in 1867 was largely achieved through negotiation and parliamentary act that was peaceful, and to that extent it was positive. But to bring about what the American spirit and the American mind had in in their thoughts about what the model of government in the United States should be, a negotiated settlement simply would not have worked. And the only way to achieve that was through the heat of battle, which culminated in 1781, the Battle of Yorktown, when General Cornwallis offered his unconditional surrender to not just Washington, but a couple of French folks that were there that had helped us out immensely, Rochambeau and Lafayette, as well as Admiral de Grasse, who had the French fleet bottling up the British in the harbor just outside Yorktown in Virginia. On both sides of the line, the people involved in these conventions that resulted in independence were remarkable people. And it's an amazing thing just to study the lives of Hamilton and Adams and Jefferson and Washington, others on one side, and Laurier and MacDonald and others on the Canadian side, to see how their minds worked, how their spirits believed, and what they wanted to accomplish on behalf of the people of their respective nations. Let me fast forward for a moment from that period, that is the Constitutional Convention, just a few years to 1801. By then, Washington had served 2 terms as President of the United States from 1789 to 1797. His successor, John Adams, was elected and served 1 term from 1797 to 1801. The 3rd president was Thomas Jefferson. He served 2 terms from 1801 to 1809. Jefferson had not been a delegate to the Constitutional Convention because he was in France serving as the American ambassador to that nation during that period of time. And I would like to read from my text just a few paragraphs that describe, I think, what went on during that time. The key point here is that Adams, the 2nd president, before leaving office, nominated and the Senate confirmed John Marshall of Virginia as Chief Justice of the United States. Reading from my text. Prior to the appointment of John Marshall, the Supreme Court of the United States occupied a relatively obscure place in the overall federal scheme. This was so notwithstanding the separation of powers doctrine that had placed the court on a separate but equal constitutional footing with the executive and legislative branches. But obscurity was about to vanish. In 1803, a case came to the court which on its face seemed of little significance, but underlying the case's simplicity was the all-important question whether the judicial power of the Supreme Court of the United States might serve as a check on Congress' ability to enact legislation in excess of its constitutional authority. This would be the equivalent of having the Supreme Court of Canada tell Parliament what it could or could not do. Marshall saw the case exactly for what it was. He concluded that in the factual setting of that case, Congress had indeed exceeded its constitutional power and proceeded in an exercise of what we call judicial review to declare an act of Congress unconstitutional. The case, known as Marbury against Madison, became not only a landmark decision in American jurisprudence, it became and remains today the fountainhead of all American constitutional law. The significance of Marbury was that the Supreme Court had struck down an act of Congress on the basis that the act was repugnant to the Constitution. In the court's written decision, Marshall states, quote, "It is emphatically the province and duty of the judicial department to say what the law is." A bold statement. Marshall thus confirmed the judicial power that the acts of Congress were subject to review by the courts to ensure compliance with developing constitutional standards. Nonetheless, Marshall made his decision stick, prompting his most recent biographer to observe, if Washington founded the nation, then most assuredly Marshall defined it. Now, if you draw a comparison between that and the situation in Canada, as history unfolded, those situations took a sharp divergence and bear very little resemblance to one another. Indeed, viewed in the context of 200 years of history, Marbury has withstood all challenges in the United States, and while the power of judicial review to declare both executive and legislative acts unconstitutional has been used sparingly, it has been used. And when used, as you can imagine, the other branches become very angry. To give but a few modern examples, it was used several times during the 1930s to invalidate several pieces of New Deal legislation enacted by the Congress during the Depression years under the Roosevelt administration. Again, in the 1952 steel seizure cases, the court held that President Harry Truman, as chief executive, exceeded his constitutional power by seizing the nation's steel mills to prevent a strike during the Korean War. In 1954, the Supreme Court handed down a unanimous decision in Brown versus the Board of Education, now a well-known case. That decision invalidated the laws of any state that would discriminate on account of race and thus prohibit minority children from attending the public schools of their choice. Similarly, in 1974, during the Watergate scandal, the Supreme Court struck down President Richard Nixon's assertion of executive privilege in his attempt to withhold the infamous Watergate tapes from subpoena in a criminal trial, indicating that while the executive privilege did exist, and again that's a separation of powers issue, there is an executive privilege. Under the Constitution, it was not an unlimited privilege, and the court told President Nixon to turn over the tapes. Importantly, the holding in Marbury a federal constitutional decision is equally binding on the courts of last resort in each of the 50 states. Moreover, the will of the people expressed through the constitutions of the several states grants judicial power to the courts which, under Marbury, includes the power to review and, where appropriate, to declare invalid the acts of state legislatures and state executive branches. Turning back to Canada, echoes of similar judicial review began to take root in Canada's jurisprudence after 1982 under the newly adopted Canadian Charter of Rights. This was literally the last step in severing Canada's liaisons and ties to the mother country, Great Britain. In a 1992 address in Vancouver, British Columbia, by retired Chief Justice of the Supreme Court of Canada, Brian Dixon, he gave predictions that he had also given in a speech made in the United States 12 years earlier in 1979. He said this, quote, "During most of the first 100 years of its existence, the Supreme Court of Canada attracted little public attention. Its judges were not well known. Its decisions gave rise to little controversy or even attention. Media coverage was meager and often inaccurate. But that is changing," said the Chief Justice. "As constitutional, economic, and social problems reveal themselves in Canada in sharp relief, the relative anonymity and the tranquility which have hitherto characterized the court and its operations seem to be vanishing. It now seems plain that in the resolution of those problems, the Supreme Court of Canada, as a vital Canadian institution, will be met with the need for prodigious judicial statecraft in the years ahead." I suggest that Canada, as a result, is going through some of the same debate and controversy as did the United States when John Marshall handed down his landmark decision in Marbury. The Chief Justice of Canada further reported that Canadian courts more and more were seizing the occasion to act as a buffer between Canadian citizens and their government, something that had never been done before. These cases, said he, saw some judges arguing that provincial legislation that infringed on fundamental freedoms should be struck down on the ground that limits on such freedoms could only be placed through the federal government's criminal law powers. Use of the words, quote, "struck down" in relation to legislation, as best I can tell, is something relatively new to Canada's jurisprudence. I spent the first 20 years of my life having been born and lived under the Union Jack. and I have spent the last 50 years under the Stars and Stripes, most of them in Arizona. Having gone through the exercise and study for this presentation, I conclude that Canadian constitutional discourse is and will continue to be informed by Canada's own set of parliamentary traditions and historic precedents. Given the independent spirit extant among Canadians of the 21st century, who suggest that Canadian values should permeate and control Canadian institutions, it seems to me those inherent values which drive national controversy towards solutions in the courts of Canada will remain thoroughly Canadian under Canada's developing constitutional framework. And I thank you very much.
Okay, we'll now have a period of questions. If you want to raise your hand, we have a mic. And if you take the mic so that everyone will be able to hear. Thank you.
Justice Jones, question for you. On that last comment interested me on how Marbury, striking that down, kind of formed the nation, and it was just after that well, it was only 12 years after the Constitution, more or less, wasn't it? Didn't you say it was 1802, Marbury?
1803, so 16 years.
I'm wondering if the lateness of the repatriation of the Canadian Constitution, if that explains part of why Canada is coming to this crossroads at present. Sense of that?
By the way, Dale, how are you? Nice to see you.
Great to be here.
It's hard to say. The United States at the time was a fledgling nation. It was experiencing enormous growing pains. There were doubts whether the system could even endure. The Constitution that was produced in 1787 may not succeed. They didn't know. They had had an experience between 1781 and 1787 where they attempted to establish the Continental Congress under what was called, under a loosely drawn document known as the Articles of Confederation. It didn't work. It failed because the powers granted the central government under Articles of Confederation were just too weak, and the government was unable to exercise sufficient authority as to govern the newly established nation. That is what served as the precursor to bringing the colonies together in 1787, where they drafted the Constitution.